I want to just introduce you to this concept of avoiding probate by using a trust. You know, any discussion of how people can avoid their surviving family members or their families from having to go through the court-supervised probate process to get things transferred when they die. Typically, every one of those discussions involves how to best utilize a living trust or revocable living trust. What's that all about, you say? Well, the general concept is it's been determined many years ago by the lawmakers that things that are in your name when you die, the title of those things become frozen when you pass away, and it's up to our government or our court system to oversee the management of it and the distribution to the right people. Well, then we have a different set of rules that say that generally things in a trust don't have to be supervised by the government or the transfer of those things upon death of the person who established the trust. Those things don't have to be supervised by the government or the courts. The trust law allows those things to be dispersed pursuant to the terms in the trust instrument. So let me give you an example. Mom and dad live in Louisiana and they own a home. And they own it in their name, like many married couples who own a home own it. Dad dies. Mom wants to sell the house. She thinks she can because, hey, they bought it together. Well, Dad's part of the home, he owned one half of it. Louisiana's a community property state. Mom can't sell the home. Dad's portion of the home has to go through probate. The court or the government has to oversee the transfer of Dad's half of the home to clear up the title and put it into the names of the right people. Where's it going to go? Well, it depends on whether Dad had a will or not. And if he had a will, Dad's will dictates who his half goes to. If he doesn't, then state law governs it. So, but the mom and the rest of the heirs have to go through that court process when Dad dies to clear up the title of that home that was in Dad and Mom's name. And then the downside is once they go through probate when Dad dies, now when Mom dies, the family's going through the probate all over again to transfer her ownership of the house to the children of the other heirs, whatever the case may be, requiring two court procedures when married couples own a home. Now let's take a different example. Let's say Mom and Dad set up a trust. Mom and Dad's names are Mike and Linda. So Mike and Linda set up the Mike and Linda Trust with Mike and Linda as the trustees, and Mike and Linda's two children, Fred and Anita, as the beneficiaries of the trust when Mike and Linda die. Well, typically that trust would be set up so that when one spouse dies or one parent dies, things just stay in the trust, and the surviving spouse is now the sole trustee of the trust, and she has those full rights to buy, sell, manage the house. And then when Linda, the surviving mom, dies, all of the trust provisions are written so that perhaps one or both of the children become the trustees and both children are the beneficiaries. So then the house can immediately be transferred to the children or sold out of the trust and the proceeds divided up among the children, all outside of having to go through any kind of court or government proceeding. So that's the gist of it. More to it than that based on the parties that are involved and the assets that are involved, but should start to be getting an idea of how people can avoid their family having to go through what is often perceived as a difficult and expensive court proceeding when somebody dies. I'm Paul Rabelais. Now, go out and leave a legacy.